The protection and preservation of the family unit is an acknowledged objective of the Sharia. Accordingly, the family system has been structured around the institution of Wilayah, which governs the authorities distributed within the family, irrespective of the size of the family. The Wali is a person who has been granted authority over the person and the property of the minor by the Sharia. He is also responsible for supporting all minors till they reach the age of majority, and even beyond that, according to some. A guardian, on the other hand, is a person appointed by the Wali and is called a wasi. The authority of this guardian appointed by the Sharia is of three types: complete autonomy for the ward, complete autonomy for the Wali, authority shared between the Wali and the ward. Where the ward has complete autonomy, it is recommended that he or she consult the Wali. The minor, male or female, is subject to the absolute authority of the Wali, whether the female is a virgin or is deflowered. The Wali also has authority over the marriage of the insane person, minor or major. The authority of the Wali in this case is obligatory, mandatory, and autonomous. The authority available to the Wali in this context belongs not only to the father and grandfather, but to other relatives as well. However, in the latter case, the minors possess the option of puberty. The Hidayah, explaining the freedom of a woman to conclude her own marriage contract, says the nikah of a sane and major free woman, whether a virgin or deflowered, stands concluded when it is with her consent, even if the Wali did not undertake this contract. This is so according to Abu Hanifa and Abu Yusuf, while according to Imam Muhammad, it is concluded but is suspended, subject to ratification by the Wali. Malik and Shafi said that nikah is not concluded at all through a statement of women, because a marriage contract is intended to meet certain objectives, and delegating such authority to them upsets these objectives. Imam Muhammad responds by saying that such upsetting of objectives is remedied after ratification of the contract by the Wali. The basis for permissibility is that she has undertaken an act that pertains to something that is purely her personal right, and she possesses the legal capacity to do so, being sane and in possession of discretion. It is for the same reason that she can undertake transactions in wealth and possesses the right to choose a husband. The Wali is asked to undertake her marriage so that she is not characterized as being immodest. The Hidayah then points out that it is not permitted to the Wali to force a virgin, who is a major, to marry. Shafi disagrees. He decides the issue on the analogy of a minor girl. The reason is that the minor is unaware of the complexities of nikah due to the lack of experience. It is also for this reason that her father takes possession of the dower without her asking him to do so. The Hanafis maintain that she is a free woman addressed directly by the communication from the lawgiver. Therefore, no one has authority over her to compel her. The authority over the minor is due to the lack of maturity of thought, which becomes complete upon attaining her puberty on the evidence that the communication from the lawgiver becomes directed towards her. She is, therefore, just like a young man, and her capacity for being free with respect to marriage is just like her freedom to undertake transactions in her wealth. The father takes possession of her dower on the basis of her implied consent, for he cannot do so if she forbids it. If a father gives away in marriage his daughter, who has attained puberty and is a virgin, and she remains silent or laughs when the information reaches her, the contract is valid with her silence amounting to consent, but if she refuses and rejects the contract, it becomes void. If the deflowered female, who is a major, is married without her express consent by the Wali, the contract is not valid. Her silence is not to be taken as her consent. Consent in such cases requires consenting to the husband, who has to be named, and the amount of dower, which also has to be clearly mentioned. If a sane and major free woman concludes her own contract of marriage, or appoints an agent for the purpose, or is married away by an unauthorized agent and she ratifies it, the contract is valid. If someone other than the Wali seeks her permission, or someone else becomes her Wali, like a brother instead of the father, consent is not given unless she expresses this in words. Silence in this case is due to the rare need of discussing the matter, for which reason it is not taken as consent. When it is taken as such, it is possible. Deeming such consent to be sufficient is only due to need, and there is no such need in the case of people other than the Sharia guardians. This is to be distinguished from the case where the person seeking permission is a messenger of the Wali, for he stands in his place. The seeking of permission that is deemed valid is one where the husband-to-be is named in a manner in which he can be identified, so that her desire to marry him can be distinguished from her desire not to marry him. At the end, it may be recalled that the system of Wilayah is no longer implemented today, although such authority has been granted by the Sharia. It is also to be noted that the authority of the Wali is to be distinguished from the authority of those guardians who are appointed by the state. As for the minor girl mentioned, she is one who has not even attained puberty. States today have made marriage of minors an offense that is punishable.